Okay, so welcome to criminal liability, and this is going to be an introduction to criminal liability. And the reason for that is that it's an enormously large subject, and I'm going to cover each of these other the elements contained within it in their own video later. So this is a whistle-stop tour around criminal liability, and just to start to get your head around some of the terms and some of the sort of words that we'll be using and what they mean. And the first place to start is with the definition of crime in itself. And there are a number of things I want to cover. The first is that crime is an issue of liability. And by that I mean that it's about responsibility. Somebody has to be to blame. Somebody is blameworthy, is liable for the offence that's concerned. The second is to talk about where we can find the definitions of crime. And there are two real main places. The first is in statute, in Acts of Parliament, and a good example of that would be theft, and we've got an example over there to look at in a moment. The second is in common law, i.e. where judges make law. And in this case, judges sometimes define crimes, and a good example of that is murder, which is not in any statute, it's not written down, it comes about as an offence as a result of the common law. The next thing to look at is the concept that crime is a public law issue. And by that, or the best way to explain that, is to look at the definition, or to look at something that was said by the judge in a case known as the Board of Trade versus Owen in 1957. And in that, the judge says that a crime is an unlawful act or default, which is an offence against the public. So that's the first thing, it's an offence against the public, and renders that person guilty of the act or default liable to legal punishment. So there are two elements there as to why public law, why crime is a public law. The first is that even though it might be against an individual, because the state have defined what a crime will be, then essentially anybody that commits a crime commits it against the public. And the reason for this is that the state has to have a way of punishing people who break the law. So we make crime a public law. And that's of course different to other elements of the law, like tort, for instance, which becomes civil. And there are two main reasons for that. The first is about mode of trial. There are two main reasons why we have a definition, why we need a definition. And the first of those is that it talks to us about a mode of trial. And what do I mean by mode of trial? Well, we've already covered that generally. We know that there are three main ways in which a criminal trial can be heard. One is on indictment, the second is summarily, and the third is either way. So our definition helps us to define which one of those three ways, which one of those modes of trial a defendant will have to go through. The second is an issue of administration. So it's an administrative issue. And by that I mean, for example, the enforcement of a magistrate's fine is the recovery of a civil debt. People owe the debt to the public. And the police cannot arrest a fine defaulter unless the police officer is in possession of a warrant. And a warrant can only come, of course, from the court system. So having looked at sort of briefly at definitions of crime and where we find them, let's show you an equation, and it's an equation that I tell all of my students to use when they're thinking about substantive law questions. And if you apply this throughout every time you look at a scenario, it should help you to make sure that you find every point concerned. And what I'm going to say is that criminal liability consists of actus reus plus mens rea or strict liability plus the absence of a defence. If all those three things are present, and all have to be present, then you can find criminal liability. Okay, so you need, in order to find somebody liable for a crime, you need to be able to show that there is actus reus, mens rea, or strict liability, plus the absence of a defence. Now, these two Latin terms I'm sure will be new to you, so don't worry too much about that. We're going to talk about those in a second. And I'm not necessarily going to talk too much about the absence of a defence in this lecture, but just be aware that in terms of our equation, if somebody has a defence, it perhaps renders criminal liability void. So let's have a look at these in turn, and let's start with actus reus. The actus reus is effectively the doing part of a crime. And it means the sort of guilty act. All right, and I've put a knife there because obviously if I was to stab somebody, the actual stabbing becomes the action, the act, the guilty act of a crime. And it consists of all the circumstances of a crime, all of the conduct of a crime, and all of the consequences of a crime are all contained in the actus reus. So the actus reus is Latin for the doing part, the guilty act itself. So the first thing, if we look at a wounding as a good example, the first thing that has to happen is that somebody has to be wounded. That would be part of the actus reus. The second element that we have up there is that the defendant has to have what's known as a guilty mind. And this is possibly one of the most famous phrases in the law, mens rea, and it means guilty mind. I cannot be found guilty of stabbing somebody if I don't have the guilty mind. So what does that mean? That means that I have to either intend to kill them or to stab them, to be reckless, or in some definitions you'll see that written as malice aforethought. So the idea is, sorry about my spelling there. So the idea is that in order to be found liable for a crime, I need to have done the stabbing, I need to have actually stabbed somebody, but at the same time I need to have a guilty mind. I needed to have wanted to. All right, so if one is the doing element, mens rea is the thinking element, and I can't be found guilty unless I have both in general terms. And the key presumption in English law is that mens rea will always be required. All right, and there's an exception to that. In a case known as Sweet versus Parsley, all right, and that is 1970, Sweet versus Parsley, 1970. It was decided that there will always be a presumption of mens rea required unless statute says differently. So unless an Act of Parliament says mens rea is not required, the judge will always take it that the guilty mind is needed. And where statute doesn't require the guilty mind, mens rea, we refer to these cases as strict liability. And strict liability is essentially where no mens rea is required. Okay, so no mens rea is required for strict liability. And so what does that mean? It means that there's strict liability arises where the crime consists of performing a forbidden act or not performing a statutory duty. So you tend to see strict liability offences covering issues of the safety of the public. All right, and I'll give you a good example of that. The Health and Safety at Work Act says that machines must have safety covers. The employers are strictly liable for that. Even if the employer asks an outside contractor to supervise the safety regulations, the employers will still be liable if the contractors do not comply with the statutory requirement. Let's give you another example, the sale of cigarettes to under 16s. It doesn't matter if I'm selling cigarettes and I believe that somebody is 18, they tell me they're 18, I've no reason to believe that they're not 18. If I sell them cigarettes and they are under 16, then that makes me liable, strictly liable for the offence. And there's another good example of that, and another piece of case law, and the case law we're going to look at is Mears versus Roberts. All right, Mears versus Roberts, and that's 1977. And in Mears versus Roberts, the defendant sold 2 children glasses of caustic soda instead of lemonade. The defendant, Mears, was found guilty of selling food unfit for human consumption, contrary to the Food and Drug Act 1955, despite another person being responsible for the cleaning fluid being in the lemonade bottle. So the person that sold it had no idea that it wasn't lemonade in the bottle, it was caustic soda, but nevertheless they were still liable for the offence. So let's just revisit that very, very quickly. A criminal liability involves both the actus reus and the mens rea, or strict liability, with the absence of a defence. You've got to have both the guilty act and a guilty mind, or it has to be a strict liability offence before you can find somebody liable or guilty. So let's have a look at our next key area, which is this concept of a result versus a conduct crime. And the easiest way to say it is that some offences require a result, an outcome, or a consequence. Okay? Murder would be a good example of that. The crime of murder requires that somebody dies, somebody is killed. That is the result of the crime, the consequence of the crime. However, some offences don't require a consequence. And that might be conspiracy, for instance. Oh, I spelt that wrong, I'm sorry. My pen doesn't seem to work this morning. And why is that important? Well, where there is a consequence or a result, and the conduct of the accused is linked to the result, then you have to prove something called causation. You have to show that the person, the defendant, caused the result. Don't worry, we will pick this up again when we look at the lesson on causation, but essentially consequence or result crimes are important because we need to show causation. Did the defendant cause the result? Conduct crimes, on the other hand, i.e. being found drunk in a public place, requires no causation. In fact, it requires no actus reus at all, let alone mens rea. The crime is simply being found. So conspiracy, if you conspire, it doesn't make the blindest bit of difference what the outcome of the conspiracy is. The mere fact that you are conspiring to commit a criminal offence would find you guilty. Okay, so that's quite important, but it's more important for us from the basis that result crimes require causation. They require the defendant to have caused the result. And we'll go over that again when we look at it. Okay, so what has to be proved? Well, in simple terms, the prosecution must prove the existence of the actus reus and mens rea beyond reasonable doubt. Okay, and we all know that that is called the standard of proof. And the standard of proof in criminal trials is always beyond reasonable doubt. In civil cases, of course, it's on the balance of probability, and we'll look at that when we look at tort. But just be very, very clear that the standard of proof in criminal trials is beyond all reasonable doubt, and that's Wilmington versus the DPP in 1935. And by that, I generally tend to tell my students that it's 99.9%. You've got to be absolutely certain before you can convict somebody. So finally, just to finish off this video then, let's look at the criminal process. What happens in when a crime is committed? So the first thing is that somebody is arrested. So there's an element of police involvement. So there's an investigation. So you've got the arrests and investigation. And sometimes those coincide, sometimes they don't. The investigation becomes before the arrest becomes before the investigation. But these are the areas in which the police are involved, okay? So this will be the police's involvement. The next thing that happens then is that there is a charge. That probably would also involve the police, so let's extend that down to there. What then happens after the charge is that it goes to court and there is a trial. After that process, we end up with the verdict, and after the verdict, there is a sentence. All right, so just remember, arrest, investigation, charge, this is the police, court, trial, verdict, and sentence is more the judiciary and the courts. All right, and we can represent that quite clearly in this sort of flow diagram. The inquiry element, the investigation element, is done by the police to gain evidence and by the prosecution when they're preparing the case. That then goes to trial, and you'll see a trial in court, which will include the verdict, and then we move to sentence or sentencing. So I accept that was a whistle-stop tour around criminal liability. What we will do now, and what we're prepared to do now, is we have some knowledge to revisit each of these areas in concern and to look at them in greater depth.